All right, good morning, everyone. How are you? Very quiet group this morning. I know it's a little early and maybe a little, it's going to be like 70 something today. So hopefully people are a little bit happy and ready to go. I know we are here in this room. All right, so we are on part 3 of our contract review. If you've seen the other versions or participated in the other versions, you know that we are almost done with the first page. It's a lot to say. So we are going to jump right in. Maybe if I find the right control, click. There we go. All right, so bottom of the page. Last section is time limit of the offer, right? So time limit of the offer is set to expire at blank o'clock, whatever M, on such and such a date. What does that mean? Like, what seems pretty straightforward, right? The paragraph that goes with it is probably one of the shortest paragraphs in the whole contract. Time period. Time of the offer shall be the date time referenced herein. Offer expires unless prior to that date and time both of the following have occurred. This is important. The offer has been accepted by the party to whom the offer was made, and notice of acceptance of the offer has been delivered to the party who made the offer. So I can't just sign it at, if the deadline's 5 p.m. and at 4:45, I sign it as the person receiving the offer. Let's say typically that's the seller, right? Buyer makes a full offer to the seller. Seller signs it and it's done, right? Binding contract? Nope. Have to send it back to the buyer in order for it to be binding. Okay? So that's an important piece of the contract to understand that that's how that piece works. It's not, and that has to be done prior to the end of the time limit. So if I send it at 6 p.m., it's not valid. Now, can all parties agree and just move forward? Sort of, and it happens all the time, but you're at risk. And this is what we talk about in this class is bulletproof contracts. We don't want to be at risk. We want to be bulletproof. So let's make sure that we have confirmation of sending notice. Now, you'll notice it does not say that the other part, the party who made the offer, has to acknowledge that they received it. You just have to send it to them. So if I'm the seller, I can sign it, send the email at 4:49, and I'm good, right?
The timestamp on the email is good.
Timestamp on the email is sufficient. Quick question about times. If seller is in California, which is obviously a different time than Atlanta, whose time drives the contract? If this says 5 p.m., what 5 p.m. is it? It's 5 p.m. where the property is. That's just kind of typical real estate law. So it's not 5 p.m. their time, 5 p.m. our time. Same thing if they're overseas in Europe or whatever, right? Like those things happen all the time. So very important that you understand that. Now, let's talk real world scenarios. Buyer makes an offer, seller says, I don't know. They go back and forth with some verbal conversation, which is always not great. But let's just say there's some back and forth. And all of a sudden, we realize at 6 o'clock with a 5 o'clock deadline that, yep, everybody wants to move forward. Can the seller just sign it and we move forward? Not really, right? Because the contract has expired. The offer, not contract, the offer has expired. And so we need to reinvigorate the offer. Now, there's a couple different ways to do that. This is where it gets tricky. If I were to go into dotloop or whatever contract system you're using and just change the time and date there, have the buyer sign, not change anything else, sign it, send it back to the seller, and the seller signs it and moves forward, is that okay? That was not a rhetorical question. And you guys are muted online, so you got to unmute if you're going to give feedback. Dan, what do you think?
I don't think you can change that. Go back retro unless Seems like there have to be another piece in there that says the time limit has been extended.
Okay, so, but remember what I said was I went back into the system. I changed that information, just the time limit, and had the buyers re-sign everything because in dot loop, as soon
Yes.
as I change it,
Yes.
their signatures go away,
Yes.
right? So they re-sign it. Now it's good to go.
I didn't listen carefully. Yeah.
Okay, so that is technically okay. It is not a best practice because it can be very confusing because now I have two offers with the same offer date and mostly the same information with two expiration dates or times, and it can be confusing. I think I've told the story of we had an agent whose seller signed the wrong contract, right? They had two active offers because both of those offers would be technically still valid. Well, except for after 5 o'clock, the first one would have died, right? So now this one becomes live. So that's a little better. But I wouldn't want to rewrite the contract, and we'll talk more about that later. But so that allows me to change it. Now, what else could I do that might be a little quicker and easier and provide the trail that Dan, you were talking about is that, okay, this originally expired at 5 o'clock. We've extended it to 8 o'clock. I can just go in and scratch out, right? I can scratch out and put 8 instead of 5, buyer initial it, always initial date and time, right? If you use dot loop or any of those types of systems, it's going to do all that for you. Don't white it out. This is a little soapbox. I think I may have talked about this before, but let's just reiterate. In a contract, if you're doing a change, an initial date and timing it, you want to see what the thing was before. So don't scribble out the 5 so much that you can't see what it said. Just put a line through it, write an 8 up above it, and have everybody initial date and time. Okay? Everybody good with that? Remember how when we started at the top of the page, we started with the offer date, even though that felt like not really an important piece because it was just at the top of the page. I want to start with the bottom, end with the bottom of the page. Well, in this portion. And this broad, bold paragraph here at the bottom says some important stuff that you need to pay attention to. I had this conversation the other day that somebody was using an older version of the contract. You can see in the corner that it says 2024. This is the current contract for this year. In 2025, this contract will no longer be valid because there will be a 2025 version. There may even be another version at some point in 2024. For a while there, we were getting a couple of drops a year. Form is copyrighted and may only be used in real estate transactions in which my name happens to be in there because I'm the one that went in and pulled it, right? So it's important that you make sure you know that your name's in there because you're responsible for the use of this form as either a member of Georgia Association of Realtors, because that's what this form is, or one of the people paying to use the forms without being a member of the Georgia Association of Realtors. Personally, I think that if you're going to pay for the form, you might as well pay a little extra and get the rest of, but anyway, that's a whole other thing. Is involved as a real estate licensee. Unauthorized use of the form may result in legal sanctions being brought against the user, which should be reported to the Georgia Association of Realtors at blah, blah, blah. So, in other words, if a random person gets a copy of this form and they're using it in a transaction that they're not supposed to, they can call that number and report you. They're going to report my name, right? Because my name's on it, right? So that's why, like the one that I handed out at the first class, it says very clearly on it, training sample. Because that way you can't use it as a real contract. I guess you could try, but it would be really weird. So just real quick things on that. All right, let's keep moving. Any questions about time limits? I know that that was a lot for a pretty simple piece. Okay. All right. We finished all the meat and potatoes of the contract, so to speak. As a vegetarian, that's a funny thing to say, but meat and potatoes of the contract. Because that's all the things that you're going to edit, right? Like that's all the pieces that you're going to, until you get to the very end, that's all of the things. And then there's this whole section called other terms and conditions. That's just boilerplate language that nobody ever reads. So let's go through it. Because, you know, like I said to Dan this morning, I've seen something new in every one of these, all of these classes. And I've been doing this for 20 years now. And I consider myself a pretty good contract person. I think people, you know, I mean, if you ask Seth, he would probably say, yeah, Brett knows the contract really well. I've been through a lot of training on it, and yet I found new things. And so we're going to go through these sections because I want to make sure everybody is paying attention. This first section about notices is extremely important. Okay. Generally, all notices shall be in writing, legible, and signed by the party giving notice. So if you're using any of the notice forms in GAR, they all have a place to be signed because you need to sign a notice. That's why theoretically email is a little bit funky because it doesn't have a signature. We were in class the other day talking about title insurance stuff, and Missy said the thing about, well, it has to have a signature for it to be a legitimate offer, right? Like it has to have a signature. So notices are the same way. Burden shall be given on to the party giving notice to prove delivery, just in case there's a question there. Requirements in the notice paragraph, even if prior agreement becomes binding. They can be delivered in person by courier, overnight delivery service, or certified or registered U.S. mail, herein collectively delivery service, or by email or facsimile. Now, that does not mean an email is notice in this paragraph. Okay? Person delivering or sending the written notice signed by a party may be someone other than that party, meaning agent can deliver or courier, not any of the parties can deliver said notice. Delivery of the notice. A notice to a party shall be deemed to have been delivered or received upon the earliest of the following to occur. Actual receipt of the written notice by the party. So I hand it to you. Hey, I got it. Okay. In the case of delivery by delivery service, when the written notice is delivered to an address of a party set forth herein, important point that we'll get to in a minute, but you notice that the address of the party set forth herein. Address has to be in here for me to be able to deliver something in person. Okay? Or delivery service. Or subsequently provided by the party following notice provisions herein, provided that a record of the delivery is created. Case of delivery electronically on the date and time the written notice is electronically sent to an email address or facsimile number of a party herein, or subsequently provided by the party following the notice of the, say that over and over again, even if it's not opened by the recipient. So that's important. I have notice, I have my signed GAR form, I scan it in or I have it digitally, I email it to the party whose email address is in the contract. Because if the party I'm sending notice to doesn't have an email address in the contract, can I send them an email and that's considered notice? It sure is not. But they can subsequently provide the, that's what that paragraph says, is that if they provide it in writing subsequently, then I can then use that going forward. Okay. Brokers authorized to accept notice for a client. So basically, unless we're acting in a dual agent capacity, which is important if you happen to be in a dual agent, which I'm sure, hope you don't. But if you're in a dual agent capacity, you can't accept notice for either party because you're both parties. So that would be silly. So you have to, they have to accept notice. They have to be delivered notice. The broker or any affiliated licensee of the broker representing the party shall be authorized to get notice. And that's basically what all this says. And it says, again, sent to the address, facsimile number, email address of the authorized agent set forth herein. If you didn't bother to put the listing agent's email address on the signature page, you can't email them notices. So,
Which brings up a question. I've seen agents send information or documents with their personal email address that's not on the contract. So I send it with a reply to both that and the one that's on the signature page.
and that is a very, very, very good practice. Because if you are communicating in both of these paragraphs, all of this so far, everything this says up to this point is that you must use the communication points that are in the contract. So if there's an email address in the contract, that's the one you need to send notices to. Now, if they have another email address that they've been using, out of courtesy, you can send it to that one also. For the longest time, it used to be during the days of fax, for those of us that were around in the faxing time, which technically is still a legal form of notice and offer and all that good stuff. But the reality is that we used to always fax things to the broker's fax number. And then the same thing would happen. Oh, agent X has a fax at their house, or lo and behold, fancy things came along. You could fax to your computer and you had your own fax numbers and all that kind of stuff. But we would always fax to the broker's number because that was legal delivery of notices at that point. And so it's the same thing. Whatever's in the contract, whatever's on the signature page, and we'll look at that in a bit, that's the information you need to use, unless, and this is the paragraph that's repeated, or the parentheses that's repeated over and over again, or subsequently provided by the party following the notice provisions herein. In other words, I can't just send you an email and says, hey, use this email instead of this one. But what I can do is on the next notice or document that I sign and send over, I can add that or change that email address, and therefore I've given you notice in writing that it is a new address to use. That makes sense?
So what would happen if notice was sent to this office's fax number? Like,
It would come out, yeah, it would come out downstairs, just like in olden days. It would sit on the machine until somebody walked over and picked it up. But again, notice of delivery, and that's what it's considered delivered if it is sent. Not that I've looked at it.
But if somebody sent it here Friday at 6:30 p.m., when would it be discovered?
I would assume that it would be discovered on Monday.
Yes.
Because that's kind of the way those things work.
Yeah.
So yes, that's why fax is much less efficient than, and here's the thing. A lot of transactions that I see don't have fax numbers in the signature block.
Is that okay?
Well, does that mean that I can now fax it? No, it means I can't fax it, right? So
you wouldn't object to that.
I would not object to that at all. If that is not a valid communication method for you, don't put it in there, because that's the reality. All right, moving forward to default. Default. Default of the contract, to me, is one of the pieces that gets misconstrued and misunderstood. And so I want to go through this very closely, and we have time. We'll make it. We're going to make it to the end of the contract today, I promise. Remedies of the seller. In the event this agreement fails to close due to the default of the buyer, seller's sole remedy shall be to retain the earnest money as full liquidated damages. Seller expressly waives any right to assert a claim for specific performance. We've had this conversation lately a number of times. And that language, which, again, I learn something, and every time I do one of these classes and I'm prepping for this class and I say, holy crap, that is different than what it used to say, right? Which is why I tell everyone, remember to read the freaking contracts cover to cover. Because this says, seller expressly waives any right to assert a claim for specific performance. That means buyer says, you know what? I know closing is tomorrow, or you know what? We're sitting at the closing table. I'm just not feeling it. Bye. they're out their earnest money. Seller cannot come after them for the house, to sell them the house, make them buy the house. Now, we all know that those specific performance suits were very difficult to win in that direction anyway, because there's lots of buyers out there that would be willing to buy a house, but the other direction, there's only one house that is that house. So, you know, you have to think about it from that perspective. But this specifically says the seller expressly waives that right to sue for specific performance. The parties expressly agree that the earnest money is a reasonable pre-estimate of seller's actual damages, which damages the parties agree are difficult to ascertain. Because everybody has a different perspective on that, so we're already going ahead and say that. The parties expressly intend for the earnest money to serve as liquidated damages, not as a penalty. That's important lawyer talk, okay? I'm not a lawyer, but I know that's important lawyer talk, because it sounds stupid. This paragraph is very important for your sellers to understand when they're accepting that offer that has earnest money of $1,000 on a $600,000 house. Because I'm pretty sure that if the buyer just walks away, $1,000 is not really a valid, what was the pre-estimate of the seller's actual damages. Even if they own the house outright, it's probably more than that. Maybe not, but it feels like it. Being off the market for 45 days, 60 days, and I get $1,000? I don't think so. So this is the paragraph that's going to drive that in earnest money needs to be an amount that makes me realize that if this stays off the market for however long the term is to close, add the extra 8-day unilateral in there, by the way, just in case. Am I going to be okay with just walking away with $2,000, $3,000, $4,000, whatever the number is? Because that's all you're getting. Okay. Remedies of the buyer. In the event the agreement fails to close due to the default of the seller, buyer may either seek the specific performance of this agreement or terminate the agreement upon notice to the seller and holder, in which case all earnest money deposits and other payments buyer has made towards the purchase of the property shall be returned to the buyer following the procedures set forth elsewhere herein. So buyer has the right to sue for a specific performance because there's just one house at 123 Main Street, right? There's no other ones like it. It's the only one there. And there, even the one down the street that's exactly the same house, it's not at 123 Main Street, right? That's where specific performance comes in. You will notice that it says, or terminate the agreement upon notice to the seller and holder. So we need to make sure that we provide previous paragraphs. How do we deliver notice, right? We need to make sure that it's a signed document that says we're terminating because seller is in default. Okay. We're going to talk about how they. Now, let's talk about rights of the broker. This is an important one. And this is the one that kind of gets everybody. In the event the agreement is terminated or fails to close due to the default of a party hereto, the defaulting party shall pay as liquidated damages to the broker in this transaction the commission the broker would have received had the transaction closed. This is a gotcha that a lot of people don't hold, but we had one recently that came in full guns a-blazing. Buyer walked away. They were like, I'm just going to have to pay the earnest money. And the listing agent said, I don't think so. You owe me $40,000.
How was that collected?
It was checks were written, not for $40,000 because we negotiated, but that's the right. For purposes of determining the amount of liquidated damages to be paid by the defaulting party, all written agreements establishing the amount of commission to be paid to any broker involved in the transaction are incorporated herein by reference. That's a lot that just happened there. Listing agreement and buyer brokerage agreement are now just made party to this, a part of this contract by reference. Did you get that? It's a big important piece, especially if you're one of those people that just slashes everything on your buyer brokerage agreement and doesn't really fill it out. Okay, well, now it's a part of this contract. And we just tried to reference it and get you commission. No, by the way, you're not getting any because you put 0. Because you weren't owed any. So, okay. Your choice. I think it's silly. Liquid damage above are a reasonable pre-estimate of the broker's actual damages and not a penalty. Again, legal talk. Attorney's fees. This is an important one too. If we don't just work it out and everybody sign and agree to do whatever we do, like the one with the 40,000 that we negotiated down, we didn't involve any attorneys in that, so it didn't cost anybody any money. But if people get their backs up and everybody starts hiring attorneys, litigation or arbitration arising out of this agreement, included but not limited to the breach of the contract claims between the seller and buyer and commission claims brought by the broker, non-prevailing party shall be liable to the prevailing party for its reasonable attorney's fees and expenses. When you lose, you pay it all. That's why we try not to involve attorneys in our disputes, right? I think we keep going. Nope. So that's questions about this section, default, because this is an important piece for you to understand. And again, it's an important piece for you to explain to your clients. Because if you're not explaining these sections and making sure they're reading these sections, they don't understand what might happen as they go through the contract. I would very much say, look, we're going to go through all the blanks in the first page, and we'll talk about each section as we go through that. But it's very important to me as your agent that you go to the other terms and conditions and read all of it, and then come back and ask me if you have a question. That's good practice with everyone, whether it's your sister, your mother, your best friend, some random stranger, a millionaire, a celebrity, it doesn't matter. I would do it always. And then, send it to them so they can look at it. All right, moving on. Risk of damage to the property. We cite this a lot because people don't understand what they're doing. Seller warrants at the time of close of the property and all items remaining with the property, if any, will be in substantially the same condition, including conditions disclosed in the seller's property disclosure or the seller's disclosure of latent defects and fixtures checklist as of the offer date, except for changes made by the condition of the property pursuant to the written agreement of the buyer and the seller. Oven was working when we wrote the offer. Oven broke. You got to fix the oven. Hot water heater goes out. You got to fix the hot water heater. If you're leaving the 85-inch TV as part of the property, it falls off the wall. You got to replace it. Tree falls through the center of the house, cuts it in half. You got to fix it. Right? That's what this says. Now, it goes into some detail. At the time of possession, seller shall deliver the property clean and free of trash. Also important to look at, because so often people are like, oh, well, whatever, it doesn't matter. No, contract says it needs to be clean and free of trash, debris, and personal property of a seller not identified as remaining with the property. So that baby grand piano in the living room that nobody wants anymore, you can't just leave it. The pool table that's kind of halfway crooked, but weighs 3,000 pounds and nobody wants to move it, you can't just leave it. Contract says you got to get rid of stuff unless you've specifically identified those things as remaining with the property.
Could you do that with a personal little sale?
You can identify it on the disclosure. Like if you know that you're not taking great grandma's piano with you when you sell the house, on the disclosure, just make the note that stays with the property. It's yours. It's a bonus, right? Bonus hole in my head. Notwithstanding, so notwithstanding the above, we talked about the tree coming through. If the property is destroyed or substantially destroyed prior to closing, seller shall promptly give notice to the buyer of the same and provide buyer with whatever information seller has regarding the availability of insurance and disposition of any insurance claims. So, tree cuts the house in half. I have good insurance. Insurance is going to pay to fix it all. it's going to take X amount of days. Buyer has the ability, and this is where buyer or seller may terminate the agreement with, blah, 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 blah. Seller, we're insurance. Buyer seller may terminate this agreement without penalty not later than 14 days from the seller receipt of the notice above. Which is interesting, right? Because if the tree falls through the house, seller can terminate. That is also relatively new. That didn't used to be. If buyer or seller do not terminate this agreement, seller shall cause the property to be restored to substantially the same condition as the offer date. Which is hard to do. The date of the closing shall be extended until the earlier of 1 year from the original date of closing, or 7 days from the date that the property has been restored to substantially the same condition as on the offer date, and a new certificate of occupancy, if required, is issued. So this contract can just live on for a year if tree falls through the house or catch fire or flood or any of those number of things, right? Which is a little crazy. But what's interesting is the seller has the right to terminate the agreement. Why do you think that is? Barry, come on, interactive, somebody.
So they don't have to repair the property in like a timely fashion or order, maybe?
Maybe, but think about this. I have a 1957 split level and one of the 100-year giant pines in my backyard falls on it and literally cuts it in half. The phrase here is that I have to make it to substantially the same condition as when the offer was written. Do you know how hard it is to build a 1957 back to the original? Like, I can't find that for my countertop anywhere. Doesn't exist anymore. They don't sell it, right? Now, the weird colored appliances came back for a little while, but I think those have gone away again. So I can't put it back into the same condition. So the effort that I'm going to take to rebuild the house, let's assume that I don't just level it and build a new one, because that might also happen given the insurance. But let's assume that we fix it and we put it back. It happened to cut through my kitchen, so I get a brand new kitchen out of it. So now my 1957 that had an original kitchen, and I'm just talking about my house, had an original kitchen to it, and no upgraded HVAC systems and blah, blah, blah. But because I had to do this repair, I now have a brand new kitchen, brand new HVAC system, redid all the wiring. Is my house worth the same as it was when you wrote the offer? Absolutely not, right? My house is now worth significantly more than that, which is why I'm probably going to terminate, because I know that when I finish fixing the house and getting it back together, it's going to be worth more than what you were paying me for it.
Quick question on the insurance. I have no idea, but if your house gets cut in half by a giant tree, the insurance company's not just going to write you a check for whatever the parameters of your replacement value is. Aren't they going to make you build it back before they pay anything?
Much like I'm not an attorney, I'm not an insurance person.
I'm just
so I'm not gonna, but I will tell you, like one of my neighbors had their house, 1950s house, cut in half by a tree. And they lived in a rental house next to us for a while their new house got built from the ground up. And I know that they got paid enough to pay off what they owed on the previous house, and enough to get started and do the financing to do construction loan to build the new house, which is now worth significantly more than what their old piece of shit house was worth. And so, you know, it all worked out. But at the end of the day, it depends on your insurance, probably.
I have no idea.
I think some insurances are better than others, as is with most things. And so, yeah, I think that's one of those things to consider. Any other questions on the risk of damage to the property? Don't be afraid when you do a walkthrough and there's still piles of crap because the seller has moved out and they left all this stuff in the house and on the property. Don't be afraid, because we've done this. Take this paragraph and highlight it with a little highlighter and send it that says that they will deliver the property free of trash, debris, and personal property. They're contractually required to do that. Now, what's the penalty if they don't? What are your options? Don't close. If you close, it's yours. And everything left in the house is yours. By law. All right, next, other provisions. Condemnation. If the property gets condemned, the seller shall immediately notify the buyer and the buyer provide the buyer with details of the same. On receipt of the notice, buyer shall have the right, but not be obligated for 7 days thereafter to terminate the contract. They get a refund of all their earnest money, blah, blah, blah. Buyer does not terminate the contract within the time frame. Buyer agrees to accept the property less any portion taken by the condemnation. And if the buyer closes, buyer shall be entitled to receive any condemnation award or negotiated payment for all or portion of the property transferred or conveyed in lieu of condemnation. Condemnation is a really messy thing. We don't see it all that often, but if you get in that, you want to talk to somebody because it's messy. Consent to share non-public information. Buyer and seller hereby consent to the closing attorney preparing and distributing the American Land and Title Association ALTA estimate settlement statement. Those of you that have been around for a while, stop calling it a HUD. It's an ALTA now. Statement combined or other combined settlement statement to buyer, seller, brokers, and brokers, affiliated licensees working on the transaction, reflected in this agreement for their various uses. So that's the paragraph that says it's okay for me as the buyer's agent to get the combined ALTA for the whole transaction. Everybody's agreeing to that. That was an issue for a little while. Duty to cooperate. All parties agree to do all things reasonably necessary to timely and in good faith fulfill the terms of this agreement. Goes on to list a whole bunch of things. Is that an important paragraph? Those of you that have been in the business long enough have had somebody either on your side as a client or on the other side as somebody that you're negotiating with disappear off the face of the earth, not respond to any communication. If they're getting communication from the attorney, hey, seller, I need you to fill this out for us to be able to do this closing, and they're not responding, they are in default of the contract. You as the buyer can terminate because they are in default. Remember, we went back to the default provisions. What can you do? If the seller is in default of a provision, this is a provision, duty to cooperate. If I don't respond for 2 weeks to the attorney and get them the information they need in order to close the deal, that's default, right? Feels like it. I don't know. Ask an attorney. Again, anytime you feel like you run up against one of these, I would definitely talk to an attorney about it because they know that's what they do. Litigating attorneys, that's what they do all day. Electronic signatures. Everybody's agreeing that electronic signatures are valid. They're the same as an original signature. This last sentence here, it says, all parties agree to promptly re-execute a conformed copy of this agreement with original signatures if requested to do so by the buyer's mortgage lender or the other party. So if somebody wants a clean copy, conformed copy of the contract with wet signatures on it, they can request it. Now it's rare, but it's valid. Now, does that say that I want a clean copy with all the changes and everything incorporated in it, and I'm going to e-sign it? No. And I've seen that request come across. That is not a valid request. I mean, it's a request. Everybody, you can ask for whatever you want. But this one, it says that it's conformed copy with original signatures. That means inked paper. Okay? Entire agreement, modifications, and assignment. This agreement constitutes a sole and entire agreement between all the parties, supersedes all of their prior written and verbal agreements and shall be binding upon the parties and their successors, heirs, and permanent assigns. No representation, promise, or inducement not included in this agreement shall be binding upon any party. Here too, agreement may not be amended or waived except upon the written agreement of the buyer and the seller. Buyer and seller don't sign it, it's not a part of this agreement. Any agreement to terminate this agreement or any other subsequent agreements by the parties or related party must be in writing, signed by the parties. Agreement shall not be assigned using SS 611 or listed for sale in any multiple listing service by buyer prior to closing, except with the written approval of the seller, which may be withheld for any reason or no reason. So if I'm flipping this house, I can't start marketing it until I own it. It's a reasonable statement, but it happens a lot. Any assignee shall fulfill all the terms and conditions of this agreement, including but not limited to the obligation to pay any real estate commission owed by the assigned or hire agreement and assignment. So does this say that if I have a contract, I can assign it to somebody else and the seller doesn't have to agree to that? See if anybody's paying attention. Anyone?
No.
No, it does not say that. Assignment has to be, the agreement may not be assigned with, except for with written approval of the seller. So I need the seller to agree to assignment. Okay? That has come up a few times recently. Extension of deadlines. No time deadline under this agreement shall be extended by virtue of it falling on a Saturday, Sunday, or federal holiday, except for the date of closing. Important statement. People love to try and extend things automatically. You can write a special stip for that. We're going to do a whole class on special stips. But the contract itself says that all deadlines are the way they fall. It's one of the pitfalls of real estate. 7 days is 7 days is 7 days. When it falls, unless it's the closing. Because you can't do a closing on a Sunday that I'm aware of. Can't find an attorney that'll do it.
For a federal holiday.
Or a federal holiday.
Transfer of money.
Because you got money that's got to change hands. So the closing can. The FERPTA affidavit. Less seller is a foreign person. According to the IRS, seller shall deliver to the closing attorney at closing a FERPTA affidavit indicating the seller is not a foreign person. Seller is a foreign person. Additional taxes may need to be withheld at closing. Important that you know that. If you're representing a seller that's selling their property, they're not getting all of their money. They're just not. It's a big chunk that gets held out. I think it's 20%. It's a lot. It's not something they want to find out at closing. Okay. So if you're working with somebody that is a foreign person, according to the IRS, right? We don't need to get into it. This is only defined by the IRS. Then that's the way that goes. GAR forms. Further on from our bold paragraph, the Georgia Association of Realtors issues certain standard real estate forms. These GAR forms are frequently provided to the parties in a real estate transaction. No party is required to use any GAR form. Since these forms are generic and written with the interest of multiple parties in mind, they may need to be modified to meet specific needs of the parties using them. If any party has any questions about his or her rights and obligations under any GAR form, he or she should consult an attorney. It's a good CYA for us as agents, right? Provisions in the GAR forms are subject to differing interpretations by our courts other than what the parties may have intended. Legal talk for just because you think it says that doesn't mean that someone else will think it says that. At the time, our courts may strike down and not enforce provisions in our GAR forms as written. No representation is made that the GAR forms will protect the interests of any particular party or will be fit for any specific purpose. The parties here to agree that the GAR forms may only be used in accordance with the licensing agreement of GAR, while GAR forms may be modified by the parties No GAR form may be reproduced with sections removed, altered, or modified unless the changes are visible on the form itself or in a stipulation, addendum, exhibit, or amendment here to there too. A lot of CYA in that paragraph for the Georgia Association of Realtors and us as agents, licensees using this. If someone is striking a paragraph, they don't like it, typically attorney clients, they need to just put a line through it and initial it, not start copying and pasting paragraphs into a different contract. If you eliminate a whole page, you can't just eliminate the whole page, just put a line through it. Questions about that one? Because that one comes up sometimes.
I've seen it on foreclosure sales where the REO says none of this applies.
Yep. REO companies, oftentimes banks, you'll use a GAR form and
Reduce.
like 90% of the paragraphs just have lines through them. These don't apply. Okay. Especially a lot of the ones at the beginning where we were talking about the default, like the broker rights. Yeah, those go away in REOs sometimes. Governing law and interpretation. This agreement may be signed in multiple counterparts, each of which shall be deemed to be a original and shall be interpreted in accordance with the laws of Georgia. No provision herein, virtue of the party who drafted it, shall be interpreted less favorably against one party than another. All references of time shall mean the time in Georgia. If any provision herein is held to be unenforceable, it shall be severed from this agreement, while the remainder of the agreement shall, to its fullest extent permitted by law, continue to have full force and effect in binding contract. No authority to bind. No broker or affiliate licensee of the broker by virtue of this status shall have the authority to bind any party hereto to any contract, provisions therein, amendments thereto, terminations thereof, or to notices signed by broker but not the party. However, if authorized in this agreement, broker shall have the right to accept notices on behalf of the party, but not send notices from the broker on behalf of the party unless they are signed by the party. This is a really important couple of sentences. I've seen over the years agents try to negotiate on behalf of their client a little too far in that they accept. You can't. You have to have a signature of the party accepting. You're not it. Unless you're part owner of the entity doing the selling or the buying, you can't do that. You're not authorized to bind anything. You're also not authorized to give notice. Notices require signatures of the parties. An email does not count as notice. We get that? People think all the time that all I need to do is send an email and say, oh yeah, it needs to be this, this, and this. Well, if that were true, I could send you an email with my offer in it, just written in, right?
Okay.
Not as an attachment, right? I could just email you the terms of my offer and hit send. But that's not true. That's not valid. Georgia law says, as he talked about this in one of our recent title classes, you must have a signature for it to be valid. We just went through the paragraphs in this contract that call that out. You can't send notice on behalf of your client unless they've signed that notice. So unilateral notice to terminate has to be signed by the person doing the terminating, not you as an agent. Of course, you can do ministerial acts, filling in the binding agreement date. In the event there's a dispute over the binding agreement date, shall be resolved by a court arbitrator having jurisdiction over the dispute by written agreement of the buyer or seller, or by the holder, but only in making a reasonable interpretation of the agreement in dispersing earnest money. So binding agreement date, we'll talk about that in a minute because that's a whole nother. But it's not, we don't have the authority to bind anything. We are not party of the contract other than in representation. Notice of binding agreement date. I told you we talk about binding agreement. Binding agreement date shall be the date when a party to this transaction who has accepted an offer or counteroffer to buy or sell real property delivers notice of that acceptance to the party who made the offer or counteroffer in accordance with the notices section of the agreement. It goes on to spell some of that out. It may be delivered by either party or the broker working with or representing such party to the other party. If notice of accurate binding agreement date is delivered, the party receiving notice shall sign the same and immediately return it to the other party. What is that referring to? If I bind the contract, which we'll get to the line where we do that in a minute, and send it over to you as the person that I accepted your offer and I bound it, because I bind it when I send it to you, right? That's the way it works now. Those of us that have been around for a while, we get confused because it's changed a lot over the years. Currently, contract says that I get your offer, I sign it, I bind it, and send it to you. Right?
More steps.
Nope, that's it. There's no more steps. That's it. That's all the steps. You're thinking back to other versions of the contract where there were other steps.
Yeah.
There are no more steps. That's it. If I use the proper delivery methods in the notices section and deliver the notice. This sentence here that says if notice of accurate binding agreement is delivered. So there's an F form or a couple of forms relevant to binding agreement date. That one is everybody agrees to this is the binding agreement date and everybody signs it. That's what they're referring to here. The other is just a notice of binding agreement date. If I forgot to fill out the binding agreement date, I can just send a notice that says binding agreement date is such and such, and again, has to be signed by who? Party given notice. Notwithstanding any of the provisions, contrary 10 of the section that the broker or licensee involved in the real estate transaction may perform the illustrative act of filling out the binding agreement date, sending a fully signed purchase and sale agreement with a specific binding date included that one of the parties has agreed to constitutes notice of binding agreement date to the other party. That's it. That is binding agreement date. Super simple now. But remember, it has to be delivered via the notices section of the agreement, which means I can fax it, I can email it, I can send it via delivery service, whether it's a courier or FedEx or whatever, or I can deliver it in person. Those are all acceptable methods. If any and all of those things are set forth here too on the signature page as ways to communicate to the other party. Okay, we'll talk more about that when we get to it. Objection to the binding agreement date. Why would someone have an objection to a binding agreement date?
They didn't get notice until the next day or something.
Right. So this is why binding agreement date has changed over the years and gone back and forth, because it's always this game of, well, the seller wants binding agreement date to happen faster. The buyer wants binding agreement date to happen later, because then I get time to schedule my inspections if I've got a due diligence period, whatever, right? All my timelines start later. So let's say my contract dies, our offer dies. I keep saying that, it's an offer. If the offer dies at 5 o'clock tomorrow, okay, and it's now, what is it, 10:30 today, and I've sent you the offer, and I've given you until 5 o'clock tomorrow to respond. Seller, you get the contract, and tonight at 11:30 p.m., you get the you decide, I'm signing this, we're going forward. At 11:30 p.m. tonight, I sign it, you as the seller sign it, your agent sends it over via email to my valid email address, everything's kosher, and I'm asleep, right? Because it's 11:30 at night. Well, I'm not, but let's say I am. What's the binding agreement date that I wrote in? As the seller, I wrote in today, right? So your clock started ticking today. Whereas for you, you didn't get the acceptance until in the morning when you woke up. So it's a little bit of a game. There's no way around it. It's just how it works. So, but that's what that says can happen, and that can happen. Okay. So if there is an objection, within 1 day, you have 24 hours, you have 1 day from receiving the notice of binding agreement date to send a notice of objection to the other party. And the objection shall be resolved by the written amendment of between the buyer and seller, execute the binding agreement date on 7/33. That is the form that has all parties agree binding agreement date is such and such. So we had one not too long ago that somebody said, oh, binding agreement was all the signatures digital, right? Like we know when people sign stuff, right? So all the signatures said the 17th, binding agreement date said the 18th. And everybody's like, well, but that's not right. Like this binding agreement, really the 17th, that's when everybody signed it. So they did 7/33 and all parties signed that, nope, you're right. The binding agreement date is the 17th, not the 18th. Okay. It's just one of those things. The absence of an agreement or binding agreement date shall not render the agreement unenforceable. The failure of the party to timely object will result in the parties accepting the binding agreement date as entered. So let's go back to my example of 17th and 18th. The person sending over the accepted offer wrote the 18th in the contract. So oops. If the other side didn't object and a day went by, on day 2, binding agreement date is the 18th. No one's changing that unless you do an amendment, which you can always do an amendment if all parties agree. But at that point, why would the buyer agree to change the date from a date that's further out that gave them more time? Right? And the seller should have, like it's the whole thing.
So what if there's multiple parties on one side or the other and their signature date is one has the 17th and one has the 18th?
So the 18th, it's when it's finally accepted, right? If not all parties have signed, it's not accepted yet. So that's a piece. All right, rules for interpreting the agreement. In the event of internal conflict or inconsistencies in the agreement, the following rules apply. This is important. Handwritten changes, control over pre-printed or typed provisions. Exhibits, control over the main body. Special stipulations, control over both exhibits and the main body. Notwithstanding the above, the amendatory clause in any FHA or VA exhibit controls over everything. Notwithstanding the above, amendatory clause FHA exhibit have control over everything. Says it twice in 2 different ways. Okay. Those exhibits drive everything. FHA, VA exhibits are everything. So to that point, and we'll talk about it in more detail when we get there, my original offer gets a conventional loan and somebody says, oh, we're going to switch to an FHA. Will you sign the FHA exhibit? No. And remind me when we get to exhibits as to why that is. Absolutely not. I got in a huge skirmish with a qualifying broker of another major company because of that. So just remember that. Statute of limitations, all claims of any nature whatsoever brought against brokers and or their affiliated licenses, whether asserted in litigation or arbitration, a sounding and breach of contract or tort must be brought within 2 years from the date of any claim or cause of action arises. Such actions shall thereafter be time barred. So in other words, if we did something wrong and you want to sue the agent, the person wants to sue the agent, they have 2 years. That's it. It is a long time. It's a shockingly long time. All right, let's try to do this last couple pieces. Survival of the agreement. Everybody knows that nothing survives except for the stuff that specifically says that it survives. And there's a few things in here that say that. Terminology, context, the agreement singular shall mean plural, vice versa, blah, blah, blah. Time is of the essence of the agreement. We did not finish. I really thought we were going to finish. We're going to do one more because we're way over time at this point. We're a good hour into this. All right, so we're gonna go into the next section and next time, which will be next week, I think, right? Yeah,
Yeah.
should be next week. Maybe it's not next week because I think I have a conflict next week. So I will send out a reminder. But we'll do the last part 4. I knew it was gonna run to a part 4 of the contract. And we'll go deep into going into the next section, the signature page, the exhibits page, because there's still a lot of contract left, right? So we've got to get through the details of those. Has this been good? Some of y'all have been in the business even longer than I have. Is this been good information? We're going through in enough detail, or are we going too deep? It's good? Okay. Awesome. All right. Thank you guys for coming, and we will catch you at the next one when we try to finish the main purchase and sale contract. Thank you all.